The importance of the seller's property disclosure statement, SPDS. In the previous section, we discussed seller disclosure red flags and the importance of carefully reviewing disclosure forms to identify incomplete or potentially misleading information. That discussion naturally leads into one of the most important disclosure tools used in Arizona real estate transactions, the seller's property disclosure statement, commonly referred to as the SPDS. The SPDS is a standardized disclosure document developed by the Arizona Association of Realtors, AAR. Its purpose is to help sellers disclose known information about the condition and history of a property so that buyers can make informed purchasing decisions. While the SPDS itself is a contractual document rather than a statute, it plays a critical role in helping sellers satisfy their legal duty to disclose material facts. The obligation to disclose material property conditions was clearly established by the Arizona Court of Appeals in Hill v. Jones, 151 Arizona 81, 725 P2, 1115, Appar 1986. In that case, the court held that sellers must disclose facts materially affecting the value of the property that are not readily observable and are not known to the buyer. The SPDS provides a structured format for communicating that information. Because disclosure is so important in protecting both buyers and sellers, the Arizona Residential Resale Real Estate Purchase Contract directly addresses the SPDS. The contract requires that the seller deliver the completed disclosure statement to the buyer within a specific time period after contract acceptance. The contract language states that the seller shall deliver the SPDS to the buyer within 3 days after acceptance of the contract. This provision ensures that the buyer receives important disclosure information early enough in the transaction to evaluate the property and determine whether additional inspections or investigations are necessary. Providing the SPDS early in the transaction also aligns with the buyer's inspection period, allowing the buyer to review the disclosures while conducting professional inspections and property investigations. Every buyer is entitled to a SPDS. Because disclosure is fundamental to a fair real estate transaction, every buyer should receive a SPDS whenever possible. The disclosure statement serves as evidence that the seller has communicated known material information regarding the property. The SPDS protects buyers by providing insight into the property's history and condition. At the same time, it protects sellers by documenting that the seller made good faith efforts to disclose known information. When disputes arise after closing, the SPDS often becomes one of the most important documents reviewed by attorneys, brokers, and courts. For this reason, real estate professionals should strongly encourage sellers to complete the SPDS thoroughly and honestly. While the document cannot eliminate all legal risk, it significantly reduces the likelihood of post-closing disputes. Sellers who have never occupied the property. In some transactions, a seller may initially resist completing a SPDS because the seller has never lived in the property. This situation commonly occurs with inherited properties, bank-owned properties, or investment properties owned by institutional sellers. Even when a seller has never personally occupied the property, the seller may still possess important information about ownership, legal status, or the property's history. For this reason, sellers who have never lived in the property are often still able to answer many questions in the ownership and property information sections of the SPDS. For example, even an institutional seller who has never visited the property can typically disclose the property address, legal ownership status, and other administrative details regarding the property. Such sellers may be able to identify whether the property is located in an unincorporated area, identify the legal owner of record, or disclose whether the owner is considered a foreign person under the Foreign Investment in Real Property Tax Act, FIRPTA. Additionally, sellers may know whether the property is located within a housing community designed for older persons under federal fair housing laws, whether the property is currently occupied, leased, or vacant, and how long the property has remained vacant. If the property is currently rented, the seller may also be able to disclose the terms of any existing rental agreements, including lease expiration dates, refundable deposits, and prepaid rents being held for the tenant. Sellers may also disclose whether they have entered into any agreement to transfer an interest in the property, including pending contracts, options, or other contractual obligations that may affect the transfer of title. Even limited information can provide valuable insight to a buyer evaluating whether to move forward with a purchase. HOA disclosures and community information. In many Arizona communities, properties are located within homeowners associations, HOAs. Sellers are often aware of whether the property is subject to HOA rules, assessments, and community restrictions. Arizona law includes disclosure requirements for planned communities and condominium associations under ARS, Paragraph 33, 1806, Planned Communities, and ARS, Paragraph 33, 1260, Condominiums. These statutes require that sellers provide buyers with important information regarding association rules, fees, and governing documents. Even when a seller has limited knowledge about the physical condition of the property, the seller may still be able to disclose information regarding HOA membership, monthly assessments, pending special assessments, association litigation, or liens affecting the property. This information can be extremely important for buyers evaluating the long-term financial obligations associated with ownership. When sellers refuse to provide a SPDS, despite the importance of disclosure, there are situations where a seller may refuse to complete a SPDS. This may occur when the seller believes the disclosure creates legal exposure or when the seller lacks sufficient knowledge about the property. If a listing indicates that the SPDS will not be provided, the buyer's broker should still advise the buyer to request the SPDS within the purchase offer. The seller may respond to the request with a counteroffer indicating that the SPDS will not be provided. Before the buyer accepts such a counteroffer, the buyer's broker should provide the buyer with a blank copy of the SPDS form so that the buyer can understand the type of information normally disclosed through the document. Reviewing a blank SPDS allows the buyer to recognize the types of issues that could affect the property and to determine whether the buyer is comfortable proceeding without receiving the seller's completed disclosures. In these circumstances, it is also wise for the buyer's broker to obtain written acknowledgement from the buyer, confirming that the buyer received the blank SPDS and understood the decision to proceed without the seller's disclosure. This documentation helps protect the broker by demonstrating that the buyer was informed and voluntarily accepted the risk, using the SPDS as an investigation checklist. Even when the seller refuses to complete the SPDS, the document itself can still serve as a valuable investigation checklist for the buyer. Each section of the SPDS prompts questions about different aspects of the property, including structural conditions, environmental concerns, mechanical systems, neighborhood issues, and legal matters affecting ownership. Buyers can use the blank form to guide conversations with inspectors, contractors, lenders, insurance agents, and other professionals involved in the transaction. For example, questions in the SPDS may prompt the buyer to investigate prior water intrusion, roof repairs, drainage issues, HOA restrictions, zoning concerns, or title encumbrances. Using the SPDS in this way encourages buyers to perform more thorough due diligence before closing the transaction. Ultimately, the SPDS benefits both parties in a real estate transaction. It helps sellers document their disclosures, helps buyers understand the property they are purchasing, and helps brokers reduce the risk of misunderstandings and legal disputes. For these reasons, real estate professionals should treat the SPDS as one of the most important disclosure tools in Arizona real estate transactions. Online discussion. Why is the seller's property disclosure statement, SPDS, considered one of the most important documents in an Arizona real estate transaction? Answer. The SPDS provides buyers with detailed information about the condition and history of the property. It documents the seller's disclosures and helps ensure that buyers can make informed decisions before completing the purchase. Why should buyers be cautious about accepting a transaction where the seller refuses to provide a SPDS? Answer. Without a SPDS, the buyer receives less information about the property's history and potential defects. This increases the buyer's risk because important issues may remain undisclosed until after closing. Why should a buyer review a blank SPDS if the seller refuses to complete one? Answer. Reviewing a blank SPDS allows the buyer to see the types of issues normally disclosed in a transaction. This helps the buyer conduct inspections and investigations that may reveal concerns affecting the property.